Okay, so good evening, everyone, and thank you very much indeed to be part of this webinar again. Fantastic to be here. This is my 97 webinars, a way of giving back, but it's all thanks to Mark Watson and Reshma Oogoroah, the Mediator, the Arbitrator, for being on this amazing day today. The talk today is on good faith in construction law, and of course, we'll go through the agenda later. So just wanted to obviously, we'll get some few words from Mark, as well as from Reshma onto the background. I just also wanted to share a slide with you in terms of giving back. It's a bit tiny. Mark gave us the giving back webinar on the 4th of July, 2020, right? It's almost 2 years. And it was on construction delay analysis. And we had a great turnout, as you can see there. 265 attended with a registration of 489 persons. Reshma gave back in webinar 26, and that was in 1st of August 2020. So already 2 years ago, I can't believe it. And then we had webinar 28 with the famous Andy Hewitts, Paul Gibbons, Reshma, and Mark. That was in August 3rd, 2 years ago. And then last year in April, we had Wada, Mark, Suryan, and Reshma. We talked about the audio dispute resolution. All these guys are on my YouTube channel, which I will share with you as we go along. And today we've got the webinar. So already you can see, I can't thank both enough. And guys, maybe a big round of applause for Mark as well as for Reshma for giving back their 5th webinar and to really give back all the time and wisdom today. So Mark and Reshma, from the bottom of my heart today, thank you so much for giving all your knowledge. It's all recorded YouTube channel as well, so people can view time and time again. So I'm just going to kick off the webinar in terms of, please don't forget to email me your name and also your feedback at the end of the webinar for me to be able to issue a certificate attendance. Mark, obviously you've done, like I said, 2 years ago we started. Maybe a quick background. Being the mediator and doing so much work in different countries right now. So just let us know who you are and what's happening right now on your side.
Anil, thank you very much. And I must say thank you for having me. I'm over the moon, excited. It's always good working with you and my fellow person. Now, I am based in South Africa. I advocate for a number of organizations. That means that I look at their claims and I take the claims either to mediation, adjudication, or arbitration. I'm accredited mediator with the RICS, and I've done a number of appointments on the mediation. And the idea came to mind after my experience in that we always talk about good faith in construction law and construction contracts, but we hardly ever see it. And that's when I reached out to the panelists and said, okay, let's put together something. And I'm very excited to be here to share my experience. I hold a Masters of Law in Construction and Arbitration, RGU, and I believe that I'd like to share that, and if I can share that and assist someone, I think I have done what I needed to do. Thank you very much, Anil.
Yeah, thanks, Mark. And Mark, just to also inform the audience, you started as a quantity surveyor.
That's correct, yes. I'm a chartered surveyor.
And then you move on to an LLM?
That's correct. LLM.
Okay. Wow. So you had a construction background, quantity surveyor by trade, and then you move on to become a lawyer mediator.
That's correct.
Awesome, awesome. You're an inspiration. Fantastic. Mark, thank you very much indeed. Reshma, maybe a few words from yourself. From a bit of background of your legal background to where you are today.
Sure. Thank you, Anil. Well, I really wanted to thank you first, Anil. What you did mention is that this is our 97th, well, your 97th webinar. And I don't know where you get all that energy and motivation to continue. We've done 5, but you've done 97 and counting. So it's amazing that you can continue to do this. And thank you very much. Thank you for having me on this panel to answer questions alongside Mark. I'm very happy to be here. So a little bit about me. My name is Reshma Oogoroah, and I'm based in the UAE. I'm a lawyer by training and by profession. I sit as arbitrator and I work as legal counsel through my own legal and arbitration practice called Neon Legal. I do spend a lot of time in the UAE and KSA and hopefully more and more time in Mauritius as well. So over my career, I've worked on many different construction claims and disputes in different countries, in UK, in Mauritius, in the Middle East, Saudi Arabia, Qatar, UAE. I've represented clients in Oman and in Kuwait as well. And I'm very, very passionate about construction. I happen to be working under a civil engineer at some point who was the partner in one of the law firms I was working, and he kind of gave me the construction bug. So I got infected and I'm now really, really passionate about construction. Yes, and I think one of the other questions you asked, Mark, is what's happening right now in the market. Well, from my side, there are a lot of disputes around.
Yeah.
I can see that compared to previously, the current COVID-19 disputes or post-COVID-19 disputes, if we may say that. In this, what I'm seeing is that people are more keen to try and resolve their disputes than they were before. So I can see in my practice that I'm settling many more disputes than I'm arbitrating, for example. Wow. Yeah, so from my perspective, this is what's happening in the market. There's a lot of disputes, and we are working towards settling them. Of course, there are a few that escalate to arbitration, and I have a few of those, but the majority of them are where I'm accompanying clients in trying to settle through negotiation and find a solution, a mutual solution.
All right. Okay, fantastic, Reshma, fantastic, Mark. I'm just doing a quick survey quickly before we kickstart with Mark on being the lead speaker. And I'm just going to share this with you now. Based on your experience, everyone watching right now, have you experienced good faith in construction law? Based on your experience right now, all of you are in the industry, some of you students, but most of you are working. Look, I'm very optimistic. I always try to see the positive in the negative. But of course, there are people who want to obviously try to do what they want to do legally. But based on your experience, have you experienced good faith in your construction law? Mark, before I reveal the survey, what's your thought on the statistic? When I'm going to reveal it now, what's your thought on that one?
I think it will lean towards no.
No, okay. So, all right, that's interesting. Reshma, what's your thought on this?
I would say yes, because for me, I mean, almost all the disputes I work on have an element of good
wow. So. Okay, so I'm going to share the result with you. Already a bad start for Mark Watson. 63% say yes. Based on your experience, they have experienced good faith in construction law, and 77% says no. So already I think it's a good start. But yeah, but then also Mark is maybe on the geographical areas as well. So it depends. Like Mauritius is a small island, so we see each other and we are bound to see each other every time. So it's in our best interest to resolve it.
Yes, it's like yeah, you're right. The Japanese culture as well. You don't find matters going to arbitration in Japan. They try and to go into good faith negotiations and settle it. And I've only got one matter in Japan that's going to arbitration. In the 2 years I've been working in Japan, only one matter has gone to arbitration. And otherwise it's being settled.
Fantastic.
If I may add something here, from what I've heard from colleagues, is that in Japan, compared to other jurisdictions in the world, parties tend to execute the awards or the judgments that they get, so we don't have to go through an enforcement process. Whereas in other countries, you have an arbitration, but then you have to go through the enforcement process in order to get.
So already we're learning so much of you. Mark, take it away. So Reshma, if I can ask you kindly to switch off your camera and put yourself on mute. Mark, if you can share your slide, we'll have a break in between when Mark stops. We'll take all your questions. Please keep sending your question as well as we do. And we'll just make sure Mark is okay in sharing his screen right now as we get you through. But I will send you all the link as well from Reshma and Mark. And I think we're good to go. Mark, take it away. And thank you very much indeed again.
Thank you very much. So, good faith in construction law. The Latin term is bona fides. What it means is that in human interactions, there must be a sincere intention to be fair, open, and honest, regardless of the outcome of the interaction. Now, I've been on matters where I've advocated for clients where contractors have come on board at a zero cost base price, and the aim is that they'll make up their losses or perceived losses through a 30% claims approach. That is not a bona fides or a good faith approach in construction law. I've also seen or been involved in matters, especially under the NEC contract, where programs are not accepted on the basis of if the program is not accepted, then the project manager can do his own assessment. That is also not compliant or aligned with what good faith in construction law is about. So it's how we interact with our opposing teams or our clients, our contractors, how we approach the contracts. That is what encompasses good faith in construction law. And I've been involved in a number of matters. And like I said, the Japanese have been an example to me in how to go about doing this. In the Japanese cultural organizations, you will go in and prepare yourself for a heated fight, arbitration. You put your best team together. You go in for arbitration. You go in with with guns blazing, guns cocked, ready to fight. 9.9 times out of 10, the matter will be resolved. It doesn't matter how prepared the parties are, the matter is always resolved through good faith negotiations. And for me, the Japanese culture and the way they approach the construction law is what I've taken out and what has actually changed my approach to construction law and how to deal in actual good faith. So, key topics we want to cover today: the duty of good faith. One of the key questions is there a universally accepted meaning? People always talk about good faith, being fair, and those type of things. But is there a universally accepted meaning? And we'll come to that answer in the upcoming slides. And then is there also an obligation to act in good faith in commercial contracts? For example, when you enter into a commercial contract, you submit your proposal, your tender. Does good faith exist? Or are you as the client trying to squeeze the contractor for the best possible deal? Is that good faith? And then when the contractor halfway down the line says, look, I cannot complete this project, and then you go out and you take them to pieces through arbitration and stuff like that, is that dealing in actual good faith? So good faith also looks at how you change your approach and how you change your attitude to dealing with actual matters. And then one of the oldest jurisdictions, the Roman law, good faith in the Roman law jurisdictions, we'll briefly touch on that. And then good faith in civil law jurisdictions, talking about 3 specifically: France, Germany, and Mauritius. And then good faith in common law jurisdictions. So Africa follows a common law jurisdiction. England and Wales follows a common law jurisdiction. Australia as well. But they may all have a different understanding because they've got different case law they will follow. And then what does good faith mean in construction contracts? NEC 3, the FIDIC, JCT. In South Africa, we have the JBCC. And then can the principle of good faith be used to terminate contracts? That is a very contentious topic, and it all depends in which jurisdiction you're in. And then also, do good faith clauses modify other clauses in the contract? Here, I place a lot of blame at how arbitrators and adjudicators apply these good faith clauses or interpret these good faith clauses, and also how parties to a contract interpret these good faith clauses. So the answer, is there universally accepted meaning? No, there is no universally accepted meaning, because every jurisdiction would actually differ. And then also the meaning of good faith in a specific contract will depend upon what is contained within that contract in terms of its commercial terms. Now, if you are a commercial manager and you're setting out a project for tender, if you tell your boss, Mr. X or Anil, you know what, for good faith, I'm going to give this contractor an extra 100 days. I won't penalize him. I'm sure at the end of that day, or by the end of your speech, you'll be packing your bags and out the door. Because in today's day and age, it's all about being how commercially astute you are. And I talk about being how tough you are, and also what type of, how best the deal can you draw out of it. And that is not the proper foundations for implementing good faith in your construction contract or any commercial contract. And also a commercial contract relates to or how the parties should conduct themselves in the contract, and what the obligations are in terms of the actual contract, and that's it in the provisions. And we'll always find that the person that drafts a contract, that contract will tend to favor that actual person. And that's why you also have in some jurisdictions a contra preferentum rule that states that if there's an ambiguity in a contract, the ambiguity will be read against the person that actually draft the contract. So I've never seen, or very seldom have I seen, and even in the Japanese contracts, I've never seen a contract which talks to, or specifically talks to a contract that is even-handed. We always favor one specific party. And I've seen that in the Middle East, Far East, in Africa, etc. Contracts generally favor those who draft the actual contract. So therefore, if it's not expressed in a contract, the good faith is not a universally accepted concept unless it's expressed in the contract and there's a definition in terms of what it means. And then the question is an obligation to act in good faith in commercial contracts? It all depends upon the jurisdiction. And then commercial contracts should not be, it should not be parties to a commercial contract should not be enforced or forced to act in a certain way. Contracts in a commercial contract will set out the obligations of each party has to each other, but it doesn't tells the parties should act in a certain way. And the base of that is that every party to a contract should act in a manner that is beneficial to his cause or her cause. That in itself takes away the foundations of good faith in a commercial contract. And then, as I said, it depends on the jurisdictions, whether an obligation exists, so a good faith obligation exists within a contract. Talking about jurisdictions, so look at the Roman law jurisdiction. So the original Roman version of contract law comprised a debt, and from a debt, it must be a promise to pay that actual debt. Okay? So, 1st century BC, the Romans recognized a bilateral contract. A bilateral contract is where each party to a contract owes an obligation to the other. In a construction contract, the contract owes an obligation to the employer, whereby he must build as per the contract, and then the employer has got to pay the contract in terms of how he's going to pay them, etc., etc. So there is a bilateral contract or example of a bilateral contract and obligations to each other. Now, under the Roman law jurisdictions, the debt and the rising from the debt of the payment, those contracts rest on the parties' honesty and sincerity of intention. I believe, in my experience, that is what is lacking in today. Majority, I couldn't say all, in majority of contracts today. Are we entering this contract honestly and sincerely? or are we in it, that contract, to try and gain an advantage and try to maximize my commercial exposure? So for example, if I'm going to go in at a zero-based profit margin, but then rely on a 30% claims approach, then that would not be, I'm not going into that contract honestly and sincerely. Same as if I am a client and I take the lowest bidder, and I know that that bidder maybe he left out a portion of the work, and I appoint him with full knowledge to say, this party has left out portions of the work, I'll appoint him, and I know he cannot complete the work, and on that basis, I try to maximize my commercial astuteness. That is not going into a contract or honestly and sincerely. So, but under Roman law, all contracts, or the bilateral contracts, were enforced by actions that included or took all matters of good faith, conscience, and equity into consideration when a remedy was actually sought. So under the Roman law jurisdiction, good faith is enshrined in those contracts. So when you look for a remedy, all remedies must consider good faith, conscience, and equity. Failing, and that is one of the best examples we have outside of outside of my understanding of the Japanese culture. The civil law jurisdiction, France, Article 1134 of the French Civil Code provides legally formed contracts are binding on those who made them. Okay? They can only be revoked by mutual consent or for reasons permitted by law. So, for example, if there's a specific breach that the law allows, you can terminate, or parties mutually agree. But in both cases, they must be executed in good faith. This is enshrined in the French Civil Code. So, therefore, a contract under the French jurisdiction complies or is reliant upon good faith principles. In Germany, exactly the same thing. You've got Article 242 of the German Civil Code that says that the obligator has a duty to perform according to the requirements of good faith and take into consideration any customary practice. So, on the German civil law jurisdiction, good faith is enshrined in the articles and must be considered when entering into a contract under the German legal jurisdiction system. Okay. Mauritius has adopted the French Civil Code because Article 1134 of the Mauritius Civil Code is exactly the same as Article 134 of the French Civil Code. And it has a state here that all contracts must be executed in good faith. They can only be terminated or revoked by mutual consent or for a reason permitted by law. But at all times, it must be executed in good faith. Where you see the word must and shall, that means it's an obligation. You can't move away from it. Normally, where the word is may, that means you've got a choice. But in this instances, the word shall is expressed, and must is expressed. And when the word must is there, that means the parties are obliged to follow that principle set out in that. England and Wales, in the traditional approach, common law is not recognized as an obligation of good faith. It is not implied in all commercial contracts, unless the contract express that term to the effect. Now, unlike the civil law states, the English law is different. But the English law itself, they try to create various remedies. So, for example, if you have a hire purchase agreement, hire purchase agreements are written in a manner, or they are controlled, or they are managed by legislation, and you cannot act outside of that. So the English law try to remedy the lack of good faith in the contract by remedying certain things. South Africa is exactly the same thing. South Africa, we've got what we call the various acts and legislation. Like if you enter into a rental contract agreement with someone, that is governed by the Rental Housing Act, Control Act. So you cannot contract outside of that, and that is what is predominantly being set up in the common law jurisdictions. So there is no implied good faith in any commercial contracts, can be expressed. Where it is not expressed, it cannot be automatically implied. And then where it's absent, you also got to look at further legislation to see what legislations would particularly cover that. Before I proceed on this, I think I would like to hand over to Reshma to talk about the Islamic jurisdictions, because I did not have a lot of experience in that, whereas Reshma is quite well experienced and versed in the Islamic jurisdictions. So Reshma, if you don't mind, I'll appreciate if you step in and assist with that, please. You're on mute, Anil. You're on mute.
Yeah, thank you, Mark. Thank you very much indeed. I had to unmute there. Reshma, thank you for putting just a quick one, Mark. Before we get to Reshma, you talk about good faith in terms of the bona fide, right? Is it bona fide? Is that how you spell it, bona fide, right? Unmute yourself, Mark.
You know, bona fide is it?
Yeah, bona fide. So you talk about, I just want to get that the interpretation right. In human, so what you're saying is in human interaction is a sincere intention to be fair, open, honest, regardless of the outcome of the interaction. I want to ask you a quick question as we get a question in. What good faith mean to you as well, from more of a construction person?
So as I said, my experience is that when I advocate for a client, I've got to take his matter, good or bad, and I've got to present the best possible argument and defend my actual client. I have to put aside good faith requirements because I've got to look after my client's best interests. So whether my client is right or wrong, I've got to present the best possible argument. But that's what we're there for. We get paid to do that. But I think it all, if we ingrain the good faith requirements at the onset of a contract, then you would find that there will be less reliance on people like myself to try and fight a matter that's gone sour, gone into a dispute. So it's all about, from a construction contract point of view, are you open and fair in your dealings with the opposing party? If you're going to go into, as a contractor, into a contract where you know that you're going to bring on board a strong commercial team, you're going to squeeze your client with every cent, you're going to claim a claim happy contract, you're going to claim for every single thing. That is where it starts. You enter into the agreement on I'll call it a bad faith situation already. There's no good faith intended. You want a specific outcome. Now, when you want a specific outcome, you're going to do anything and everything in your power to get to that outcome. And that is the opposite of good faith. And that is what I see and experience in the industry.
Fantastic. Yeah. Thanks, Mark. Reshma, before you share a few of your experiences on what Mark has shared in terms of presentation, from a legal point of view, from a lawyer's background, what's good faith for you? Obviously, most of us are from construction industry, but what's good faith for you from your side?
Well, yeah, thank you for the question, Ania, and thank you for such a great presentation, Mark. Well, when I learned that we were going to be talking about good faith today, I decided to go back to basics, okay? And I checked the definition of good faith in various dictionaries.
Yes.
And I found in the Oxford Learners Dictionary that good faith is defined as the intention to be honest and helpful, which is what you just mentioned, Ania. Okay, now to go deeper into the legality of what good faith entails, I looked at the Collins Dictionary of Law, which defines good faith as a requirement in the law importing an absence of bad faith more than anything that can be treated as equivalent to honestly and decently. It is embedded in civil legal systems, but is of lesser significance in the Anglo-American system. And just to add to that, for the People's Law Dictionary, good faith is defined as an honest intent to act without an unfair advantage over another person, or to fulfill a promise to act even when some legal technicality is not fulfilled. And the term is applied to all kinds of transactions. Now, when we look at this in the construction context, and we look at it from a legal perspective, very often we would insist on technicalities. We would say this procedure or that procedure was not followed, and therefore we're entitled to X and Y or Y and Z under the contract. And to some extent, what good faith is informing us or encouraging us to do is not to stick to the technicalities too much, but to engage in a practical perspective, and from a contractual perspective. This is something that's being considered, and as Mark said, it varies from case to case, it varies from jurisdiction to jurisdiction, and it's evolving, okay? It's something that continuously evolves. And I came across two interesting Australian cases where, for example, according to the High Court of Australia, an element of good faith will be fairness in dealings between contracting parties, and it is wider than honesty. And according to the Federal Court of Australia, the obligation of good faith means to act honestly and with a fidelity to the bargain. Okay, fidelity to the bargain. An obligation not to act dishonestly and not to act to undermine the bargain entered or the substance of the contractual benefit bargained for. And an obligation to act reasonably and with fair dealing, having regard to the interests of the parties and to the provisions, the aims and purposes of the contract, objectively ascertained. But acting in good faith does not mean that a party has to act against its own interest, okay? So in this case, it was said that good faith is likely to involve elements of fairness, honesty, reasonableness, not undermining the contractual objectives, not acting arbitrarily or capriciously, and having regard to the interests of the other party without having to subordinate one's own interest to the interest of another.
Wow, okay. Thank you very much indeed, Reshma. Just picking up a quick, before we pick up the questions, Mark, in terms of contract, it could be FIDIC or it could be any other contract you use to, maybe JCT or NEC. Is there good faith mentioned in it? Because I haven't seen it.
In NEC, the famous clause, subclause 10.1.
Wow. And in NEC, which is the new engineering contract, you've got good faith, and it's clause 10.1.
10.1 is.
And is there anything in FIDIC by any chance?
There is the implied term in FIDIC. You could argue that the contractor must proceed with the work under 8.1 diligently, without delay. You could imply that is, you could argue that's a good faith provision, and then and then there's a termination, a breach clause that if you breach that proceeding the work diligently and without delay, without undue delay, then you could terminate the contract. Whether that's a good faith clause or whether that is a obligation, it's debatable. But generally, FIDIC is the implied term, a good faith, and under JCT as well. But NEC is a contract that expresses it very clearly.
In NEC, they spell out good faith.
Yes, parties, the project manager, the employer, the contractor, supervisor shall act cooperate with others, something like that. But there is also a downside to that NEC clause, but we'll get to that.
Yeah.
So whilst it's expressed, how do you enforce it? And what happens if the parties don't act in terms of 10.1? What happens?
Wow. Yeah, exactly. And Reshma, just quickly, from a lawyer's point of view and an arbitrator, are you keen to actually spell out the good faith clause in there to get some clarity, or will it make it more confusing?
Well, in the jurisdiction where I work mostly, which are in the Middle East and Mauritius, the reason this part of the world is that often we are in a civil law jurisdiction, but sometimes parties elect for their contracts to be governed under English law, for example, or another common law jurisdiction, mostly English law. And this is where it becomes a little I mean, there's a lot of debate going on around that. So, for example, I did have a contract. I did have a case where I was acting as counsel, and the contract did not have an express overall good faith provision, and it was a contract governed under English law between Middle Eastern parties. And so I argued on behalf of my client that there was a duty of good faith in the contract, because somewhere in the contract there was they had actually spelled out that the parties should negotiate in good faith in respect of the performance bond.
Yeah.
And so I argue that this should apply to the whole contract. And then there were other things, like I said earlier, it's not just on one thing, but there are different perspectives that you could take. So there were other arguments, like, for example, the parties are based in the Middle East, where a duty of good faith is implied. And also this was in relation to a long-term contract, a relational contract. So we also argue that in this particular case, under English law, a duty of good faith could be implied. So yeah, these are a little bit the considerations, and depending on which side you're on, how
Let me just pick up a quick questions. There was one question you answered, Reshma, was where Raymond said, not only Japanese like to avoid arbitration, Chinese firms also like to settle over dim sum. One word for China, and Raymond, word for Chinese. Well, what's your thought on this on a dim sum?
Yes, I work with a number of Chinese companies in South Africa, and my experience is that they don't like to settle. they say, Mark, we don't want any less than this, and you go for it. Yes, so they would settle, they would attempt to settle, but they would not. They would go all out, and they would fight. They are a lot more, I would say, aggressive in the approach than the actual Japanese, in trying to get what they believe that they're entitled to. And they don't easily settle, but there is always an element of negotiation. But I won't say it's in bad faith. It's just that the Chinese are a lot more aggressive in their approach to claims. That's my experience.
So once again, it's about the geographical location, right? So where your side is more of a tough cookie, whereas on our side, we can go for a wagamama or a dim sum and sort it out. Reshma, you said, your friend said, yeah, it's the case. What's your experience from our colleague from the Chinese industry?
Yeah, so from my perspective, I mean, I haven't worked on cases in those jurisdictions. So whatever I'm telling you is from my other colleagues. So my colleagues do tell me that in Asian jurisdictions, in East Asia, parties tend to be more keen to settle and to enforce, to execute any judgments or awards. In my personal experience, I've worked on a couple of cases against Chinese parties. I was acting against the Chinese party, and those cases did not settle. They went through the arbitration. So yeah, this has been my experience, but I cannot. I don't think I can form an opinion based on these couple of cases. I think we should look at the statistics.
Awesome. Thank you very much indeed. We'll just pick up some questions. We've got Purushottam. Yes, you are right. In all the claim we see nowadays, there's no good faith element. The contractor is more greedy. The owner is acting in bad faith. How do the mediators see when the remedy is often through the court and the arbitration is not stipulated? Maybe Mark can pick on this quickly, and then I'll move on to Reshma.
So mediation is a lot different because the parties agree to act in good faith. The parties agree to try and settle the actual matter. You don't go to mediation with the idea that you're going to get what you want. You go to mediation with the idea that this is my claim. I'm prepared to walk away from this with this. So in mediation, you have what we call a BATNA, best alternative, and WATNA, worst alternative. And somewhere between that lines, the parties will agree. So in mediation, unless you are in mediation, often I find that the parties are more amenable to negotiate, to act in good faith, to negotiate in actual good faith, and try and actually settle. I've also seen instances where parties, they are compelled to go to mediation before they go to arbitration. What they do is they just go through the motions. Lodge an issue to mediation, go there, they're disruptive, they got no intention of negotiating in good faith. All they want to show the arbitrators, Mr. or Mrs. Arbitrator, we have gone through the motions, we've gone through mediation, now we come to arbitrate. That's where they always wanted to be. And you will find that the matters where tend to fail in mediation, it's where the parties have got no interest in mediating, or one of the parties intermediating, they want to go to arbitration and they want to take the matter to arbitration. But other than those issues, mediation always act in good faith.
And Mark, you just raised a very good point there. If you're going into mediation, good faith kicks in, because that's the whole point. We all want to make sure it's a nice, amicably settlement, as opposed to us coming negatively. So thank you very much indeed there, Mark. Reshma, what's your point on this? And have you seen mediation rolling up into arbitration?
Yes.
Wow. Yes. So Mark hasn't done his job properly. You get, and then it turns into arbitrating.
No, it's not about the mediator not doing their job properly. Like, seriously. Like Mark said, sometimes the parties come to mediation and all they want to do is go through the motions because it's a mandatory step in the agreement.
Okay.
But I'm happy to share that I feel that this is changing. From what I'm seeing, this is changing. Because there has been a lot of awareness around mediation. So previously in the Middle East, people weren't very familiar with mediation as we know it. They were doing mediation, a more informal type of mediation where, you know, an elderly person would try to find a solution between the parties, like somebody known to the companies and stuff. But now I think there's been a lot of work from institutions, from the private sector, to try and push for mediation. And now I can see that parties are taking it more seriously. There's still a lot of work to be done. And also, there's an interesting situation that happened. So when I moved to the Middle East a few years ago, I had a very big mediation and I was really excited about it. And I told a colleague, a very senior colleague about it. And he told me, oh, Reshma, you know, don't put your hopes up. Mediation doesn't work here. And I was very disappointed, I have to say, but he was right. It didn't work. But I saw the same colleague at the beginning of this year, and he told me, oh, Reshma, you know, I'm going to do my mediation accreditation. And I'm like, what happened? And he said, you know what, clients are asking for mediation now. So, you know, I better get to grips with it. So
Reshma, do you think it's a change in mindset, culture, more awareness, more webinar, more workshop to settle it?
I think so. So webinars like yours is raising awareness. And then, like I said, there's a lot of work being done to raise awareness in the UAE specifically, even in Saudi Arabia, actually, that there are quite a lot of educational platforms offering mediation and explaining what mediation is.
Mark, you said on your slide that the common law in the UK, England and Wales, which Reshma has experienced, does not recognize an obligation of good faith is implied in all commercial contracts. Surely this is a bit contradictory all over the world, right? Because you've started with the others where it does imply, but in UK it's a bit different. Why is that?
I think for one is that under the UK law, that, like I said, they've got a number of other laws, legislations that tends to deal with specific areas of bad faith. For example, like you have the Housing Act, Generation Act, you have a Hire Purchase Act agreement. So there are specific legislation that talks to that. And what common law jurisprudence say is that you cannot force two parties to act, because good faith talks about as action. You cannot force two parties to act in a specific way that may be contrary to their commercial needs. And I think that, and from a common law jurisdiction in England and Wales, they pay regard on the commercial side of it, and on the legal content of it, and unless it's expressed, you cannot imply it in the contract. And I think that is where they've come from. They've built up their case law over a number of centuries, and they have considered a number of things, and they have tried to address a number of issues around good faith in certain key different contracts, but in the commercial contracts, they tend to steer clear of that unless it's expressed, because the parties to a commercial contract can agree what can go into a contract or be excluded. And the parties, if they are astute commercial people, can then state, we would like to have a clause of a good faith clause written into the contract. Nothing prevents him. So the law doesn't want to enforce something that the parties can agree upon.
Yeah, absolutely. Reshma, what's your take on it, please?
Yeah. So the rule, as Mark has said, is that there is no implied duty of good faith under English law, right? But there are instances where one could argue that there is an implied duty of good faith, and generally those would be what are referred to as relational contracts. And depending on the facts and the context of a particular contract, those could be, for example, joint venture agreements, franchise agreements, long-term distribution agreements. So really, the rule is that there is no implied duty of good faith, but there are instances where you could derive a duty of good faith from the specific context and facts of a contract.
Okay, fantastic. Mark, thank you. And Reshma, thank you very much indeed. We are the last part now. Mark, if you can show your screen back in, and we'll just finish off with all the remaining slides, and then we'll take the questions at the end before we conclude. Give or take, we've got half an hour. So it'd be great to get lots of questions before we conclude this amazing webinar. And I can't thank you so much to share all your insights and experience on that one. Yeah, so take it away, and thank you, Mark.
Thank you very much. So what does good faith mean in construction contracts? And this speaks to the question posed around contractors are greedy and clients try to squeeze them. So especially in the NEC, you talk about parties acting good faith, mutual trust, cooperation, respect, collaboration. Those are all terms that refer in one way or another to acting in good faith. However, by themselves, they mean nothing. Because if there is no express term that sets out or describes precisely what they mean, or how they should be complied with, or what the remedy is, there's nothing complied with, then it's basically taken up space in the actual contract. So, for example, when a matter goes to dispute, you will always find in some form of a claim, a statement of claim, argument that, as Reshma said, hasn't acted in good faith and blah, blah, blah. However, the tribunal, whilst the tribunal can consider that, they're also limited. They cannot make and I've actually challenged a DB on this matter some time ago, where, for example, I act for a client, employer, a huge infrastructure project. This contractor typically is a terrible contractor. In terms of verdict, you got to issue your notice within a certain time frame. You can get time barred if you don't issue it. Then you got to issue your first claim, and then if it's ongoing, issue interim claims every month, and then your final claim 42 days, depends on what's in particular conditions after the event ceased. This contractor issued his claim 1 year after he notified this event 1 year after it occurred. As an employer, I said, no, sorry, Mr. Adjudicator, this matter cannot not be for improper. It should be kicked out because it's a time bomb. What the DB tried to do was he tried to create reasons as to why the employer should not adopt that stance. That is not the adjudicator's role or function. He cannot imply or cannot rely on and say the parties must act in good faith and try to resolve it or something like that. Contract is clear. And if there's no express term in the contract around what good faith is and what the remedies are, then the tribunal or adjudicator cannot
Reshma, can you hear me?
You can reduce it by a couple of days. If you want to, or give it no. I had a matter, one of our, we only got one nuclear power station in South Africa. And I was asked by the tribunal to provide an opinion on the two experts report. And I stated, and I said that the parties are not acting in good faith in mutual cooperation. What that resulted in is that this project was valued at 1.8 billion rand. Every claim that was presented to the tribunal was in excess of the original contract value. So a project that was at 1.8 billion rand ended up costing taxpayers close to 10 billion rand. And this was an NEC contract. The parties did not act in good faith, mutual trust cooperation, but there was nothing they could do about it. The adjudicator couldn't do anything about it. He could only award on the facts, decide on the facts. So without that, an express good faith term in a contract, and without linking obligations to it, you have got no remedy. You cannot terminate because of that, unless there is an express term in the contract that says, if the parties don't act in good faith, you can terminate. I doubt that I will find any such term, because you cannot just, it will not be a material breach, and it can be a challenge, in fact. And as Reshma said earlier, it's got to be linked to some other clause or other type of remedy in the or breach in the contract. So to answer the gentleman's question, if there is a good faith clause, if there's no expressed definition in terms of that, or how to remedy it, then you cannot just terminate on good faith. But it also depends upon the jurisdiction. But I'll get to that, I think, in this next two slides time. So there's two cases in English law. In the first case, 1982 of Water vs. Miles, this clause required the parties to negotiate in good faith. Okay. However, when it went to arbitration, it was decided, it was stated that it was unworkable in practice because there was no, the express term was not linked to how they were executed. Because how do you enforce people to work in good, to negotiate in actual good faith if a negotiation is not something that you can be forced onto someone? Parties enter negotiation at their own will. So when there's a negotiation, you cannot force parties to negotiate in actual good faith. And you got to make sure that when you write in that clause in the contract, that is workable, and it's practicable, and it can be executed, or it's workable. And this is a case, one case where it was said it was unworking practice, and the matter was kicked out. But in the 2002 case, Cable and White versus IBM, there was a requirement to act in good faith in terms of alternative dispute resolution, and the tribunal found that this clause was clear enough to be enforceable and include actions that will need to comply with the obligation. So this was, in this case, the clause relating to good faith was clearly set out. It was clear. It was not ambiguous. It was workable. It was enforceable, and it attached an obligation to it. And I will always recommend that parties want to include a good faith term in their contracts, they seek legal counsel in terms of that, so that it doesn't conflict or create a conflict within the broader picture. Okay? So this is the English and Wales jurisdiction. One matter, unworkable. Second matter, it's expressed, it was enforceable, and it was clearly written, and they won the case in terms of this. And then, as I said, can it be used to terminate contracts? Where there is implied good faith term, on says no, cannot use it to terminate. Where there's an express good faith term, it does not restrict a separate clause in the contract entitling either party to terminate. So if you have an express term in the contract, it must act in good faith. That good faith clause does not restrict the parties from terminating the contract under the conditions of the contract. Okay?
And Mark, just a quick one. Would you mind just tell us the difference between imply and express from a legal point of view?
So implied means that there's no written words that says the party must act in good faith, but there's always an implied requirement to act in actual good faith. Express means it's written, it's expressed within the contract, it's stated within the contract that the parties will act. Under NEC 10.1, it's expressed, stated there how the parties must actually act.
Thank you, Mark.
Not expressed. And also what's very important in terms of termination, the Islamic jurisprudence differs. And this is where I need to step out and I need to hand over to the arbitrator.
Okay, we'll just stop sharing there. I'll do that for you. And we're just going to stop sharing there. Reshma, if you want to just please support that as we get to the last slide. So maybe a few insights from you when we come to the Islamic jurisprudence traditions.
Sure. Thank you, Anya, and thank you, Mark. Well, we've heard quite in length about how there is no implied duty of good faith in common law jurisdictions. And in contrast, generally there is a positive duty of good faith for a party to perform their obligations under the contract, which is consistent with the principle of good faith under Middle Eastern jurisdictions. And as we heard before, it's also called a fidelity to the bargain. And this is not universal in the sense that there
what did you say? What bargain did you say?
I said fidelity to the bargain.
Fidelity to the bargain. Thank you.
Being faithful to the bargain. And when we're talking about the Middle East or the Islamic jurisdictions, they are not all the same. Okay, they have a similar civil code. In Saudi Arabia, there's the Sharia that applies. So, for example, in Saudi Arabia, the Sharia principles recognize a general duty of good faith under the maxim, there shall be neither harming nor reciprocation of harm. And in other countries, in other Middle Eastern countries where there's a civil code, for example, in Qatar, under Article 172 of the Qatari Civil Code, the law provides that the contract must be performed in accordance with its contents in a manner which is consistent with the requirements of good faith. And in the UAE, under Article 246 of the Civil Code, it's provided that the contract must be performed in accordance with its contents and in a manner consistent with the requirement of good faith. And it goes on to say that the contract shall not be restricted to an obligation upon the contracting party to do that which is expressly contained in it, but shall also embrace that which is appurtenant to it by virtue of the law, custom, and the nature of the transaction. So it's a provision that effectively expands the contract. So you've got the provisions of the contract, but it also tells you that you have to consider the law, the custom, and the nature of the transaction itself. And with regard to termination, there is a judgment in the UAE by the Court of Cassation which determined that under Article 46, which is the article that which is related to good faith, that Article 246 could permit the rescission of a contract where a duty of good faith could be evidenced. So that's a little bit an overview. So basically, the performance of a contract is not limited to the express terms of the contract. It also encompasses additional obligations which can be implied. Like we said, from the transaction itself, from custom, or other traditions, which can be considered as good faith.
Perfect. Thank you. Mark, if you can just finish off your last slide, and then we'll just take Q&A for the next 15 minutes, and then we'll wrap up. If you can just please share the last slide as we conclude on the and your final bits and pieces. Thank you, Mark.
Okay, so from a Mauritian law perspective, we really discussed that it's part of the Civil Code, so good faith does apply there. It's considered in all their actual contracts. English common law perspective, if it's not expressed, it cannot be implied against all commercial contracts. As Reshma said, there are certain contracts that can be implied in terms of a joint venture agreement and also franchise agreement. The Islamic jurisprudence tradition perspective, I was on a matter on a project in Lebanon. A contractor, we acted for the employer, and the contractor was a German contractor with a joint venture party that was a Lebanese company. And it was a FIDIC MBD book, which is the pink book, the harmonized version, 2010. And what transpired there was that the contractor was late. The engineer was an English based person, and he came from a common law background, and he never understood the Islamic jurisprudence requirements, and he executed the contract as if he was in England, and that ended up in dispute. And I was brought on board to assist, and what that opened up my eyes, because under a common law perspective, the engineer was 100% correct, was within his rights, but because the project was in Lebanon, it followed a different jurisdiction. There was a number of matters that were brought before. The number of legislation was brought into the fore, which I can consider as well. And yes, so whilst you are a common law background, you have to be careful where you work and how you apply the various jurisdictions, because what will work in a common law jurisdiction or in a civil law jurisdiction may not necessarily work in the Islamic jurisprudence jurisdiction. So that is very, very important. From South Africa's perspective, South Africa tends to follow the English common law perspective. And again, there is not we do not, although there's a number of arguments raised, a number of matters about an implied requirement of good faith, it's got to be expressed to be enforceable. And also our local contract, which is JBCC, there's no good faith clause expressed. And also it cannot just be automatically applied. So we tend to follow the English common law perspective when it comes to that. But as I just said, that even if a contract expresses a good faith clause, it's got to be workable and it's got to be a remedy attached to that. And when you're going to threaten someone, your contractor or your employer, that by itself does not subscribe to the requirements of good faith. So you don't threaten them under the contract. You work in terms of the contract, and where the contract is silent on those mechanisms, utilize those mechanisms that are available to you. And if you want to ensure that the good faith clause is workable and there is a remedy to it, approach legal counsel and have a robust clause written into the contract.
Okay.
That's for me.
Fantastic. I just want to share something quickly, Mark. This was at the back of our session last year. And, you know, this was me being naive. And I was reading Building Magazine and I thought, let me share that with you. I'm sure you remember that when we did our last one. Let's act in good faith, always, not just during COVID. And that was from Tony Bingham, who is a barrister and arbitrator at Free Paper Building, very famous arbitrator. And what he says in there was emergency government guidance on contract urges us to behave responsibly during the pandemic, but why only now? So he goes on to say, in all the COVID-19 rule, there never was a legal requirement for people to maintain 2 million separation. Folks have been bombarded with these so-called rules, but only some are a legal obligation. Others are merely cabinet office guidance. So obviously what he says in there, as to the dispute in particular, the government would strongly encourage this party to seek to resolve any emerging contractual issues responsibly through negotiation, mediation, or fast-track mechanism before these escalate into the formal intractable dispute. It goes on to say, for example, the RICS, which is the Royal Institution of Chartered Surveyors, has developed the low-value dispute model education procedure. Let me say at once that this device is already working well, which what you guys are saying today. I never thought that we will have a webinar on it. He also goes on to say, if there's any good to come out of this dreadful episode of COVID-19, it may well include this good faith and fair dealing, which we talk about more, fair dealing attitude. There's a real possibility of the dispute deciders hereby applying standard of fairness to contract with an eye to the current emergency. Because, we tend to forget, there was a very horrible COVID-19 right behind us. And then he goes on to say the idea of becoming embedded thereafter. And finally, he goes on to say, let's act in good faith always, not just during COVID. Okay? So I'm going to try to stop the screen here and then just share something else with you. And he's then come back to us, and I'm going to share the screen with you here, Mark. You can see that was last year in December. Okay? And you just hit it on the nail, Mark. The court explained a particular clause that sits smack bang on the first page of NSC contract. Clause 10. In the NSC contract, this clause reads, the contractor and the subcontractor shall act as stated in the subcontract and in a spirit of mutual trust and cooperation. And in NSC 4, it says, the parties, the project manager and the supervisor act in a spirit of mutual trust and cooperation. And that's to do with the recent case of, I'm just going to highlight there, the recent case of Van Oak UK Limited versus Dragodus UK Limited in the Scottish Court of Appeal. Is it exactly pebble in the pond? And this is what he says about the new ruling, shows you can't breach part of a contract, then use the contract machinery to turn that breach into your favor. So already we are, Reshma, if you can put your video on as we take the final questions, but already there you can see that what we just talked is there, is active. What's your thought on what Tony Bingham mentioned in COVID-19, Mark, when we picked up that quote?
Yeah, look, I think when the pandemic hit, there was a huge need to work in terms of this requirement as set out. What I'm finding now is as we move out of the pandemic in some parts of the world, we're reverting back to that commercial astuteness where we got to win at all costs. And I think if we think back 2 years ago, the world was a very different place. And if we continue with what approach then, I think we would see a decline in disputes. What I'm seeing now is a huge increase in disputes. Last year alone, I probably worked on about 20 dispute matters.
Sure.
20 this year, and this year is August, I'm already on 30 disputes.
Wow.
And majority of them either relate to COVID or they flow from COVID. So I think people have forgotten about the good faith and working together and being my brother's keeper. And now we're back to that cutthroat, trying to survive commercial dispute world. So I think that what you presented there is very, very important.
And this is where webinar like this Mark comes in, Reshma. Maybe this is where we need to keep kind of have the awareness, those workshops. What's your thought, Reshma, on Tony Bingham good faith in COVID? And you must have worked in COVID-19, which was a truly, truly difficult time for us, Reshma. What's your thought on that, good faith in COVID-19?
Thank you, Anil and Mark. Mark, I would be interested to know, at what stage of the dispute you come in generally? So is most are most of the disputes that you're talking about already in arbitration, or would they be somewhere, you know, during negotiations or prior to arbitration?
Most of my on the one matter, one client I got, they have brought me on board in preparation for the disputes.
Mm-hmm.
So a number of matters have gone through for determination by the engineer. They've raised the notes of dissatisfaction, and they brought me on and they kept me on board. They keep me on board for 2 years just to take their matters to arbitration, to mediation, adjudication, and arbitration.
Mm-hmm.
That has shifted. Whereas prior, I was brought on board when the matter was being really set down for arbitration.
Mm-hmm.
Now I'm brought on board at a much earlier stage in order to enhance,
to prepare for
options.
Yeah. That's very interesting because my experience is very different. I feel that clients have actually, both clients, like contractors and employers, have learned from COVID, and I see a wider willingness for parties to settle. Maybe I just attract those types of clients, I don't know.
Mark, which part of the world are you working where everybody's getting the fruits? I want to know about that.
I'm working in the USA. I'm working in Africa, in South Africa, and also in other parts of Africa. I'm working in Sri Lanka, Bangladesh.
Wow.
Yeah, so those are, but the ones in Sri Lanka, Bangladesh, we are preparing for a fight, but we are with the aim of negotiating. We just had a matter against Saudi Aramco, who's a Japanese client of mine, and the claim was for $600 million, sorry, and Aramco offered some crazy $20 million, and it was set down for arbitration, but we entered into a protracted negotiation, and the parties agreed, and a client walked away with just over $200 million. It was happy with that. So we're finding that, and again, that's a Japanese client again, but in other parts of the world, I'm a hired gun. I'm being paid to get the best possible solution for the clients.
And Reshma, what sort of part of work? Obviously, you are much more in the Middle East, so it's quite, what you say is very much different from what Mark's saying.
Yes, that's my experience. So it may be that, you know, with other lawyers, it is similar to what Mark is describing. There are many disputes, okay? There are many disputes because of COVID-19. But when it comes to my experience, what I'm seeing is parties are sitting down and talking about, okay, how do we settle this? How do we find a way to continue to work together? And I also have a very keen interest in dispute prevention and avoidance.
Yes.
And I suppose this is why the clients who come to me because they want to settle, not because they want to fight. Although I do fight, I do have a couple of ongoing arbitrations where I'm representing clients as counsel. So, but we always start with the less adversarial means of resolving a dispute. So we start with informal negotiation, we move on to formal negotiation. Then if there's a scope, we try an expert determination or mediation. And only if those do not work, that we go to arbitration or litigation.
Okay. We'll just pick up the question before we conclude. We've got 10 minutes left. I've got a few things to share. Mark, we'll get back to Ryan, our chartered QS colleague. To what extent does an absence of good faith, does this allow an aggrieved party to terminate or threaten to terminate and sue for damages? For example, absence of valid determination or refusal of awarding an EOT. Maybe a few words. I know you touched on it, but just to in response to Ryan.
No, you won't be able to use your good faith clause, to terminate, unless there's an express provision in the contract that allows you to terminate. But if there's a determination that is not done correctly, you would have to raise a dispute under the contract mechanism and then take it to the formal dispute resolution process. But at no stage should you threaten to terminate, or nor can you sue for actual damages. The contract will set out, and I'm not sure which contract we're talking about, but the contract would actually set out your remedy available to you.
Fantastic. Thank you. Reshma, a question from Raman. In a shake-hand contract between a contract and a client, can terms in the shake-hand contract supersede clauses in FIDIC? So essentially saying shaking hand contract can supersede clauses.
Yeah. So I'm assuming here that the FIDIC contract was put in place of the shake hand agreement, in which case we need to look at the FIDIC contracts. FIDIC contracts are heavily amended. I think Mark will agree with me. So it may be that there is an entire agreement clause in the contract that says that this is the entire agreement and anything that was agreed beforehand no longer applies. And this is generally a boilerplate provision that would be in a contract, not just a FIDIC contract, but in any other contract. So it may be difficult to try and implement something that was agreed before, but obviously there's correspondences, there's communication that proves the point, then one could argue that position should apply as opposed to what's in the contract.
Yeah.
Also, other legal question, it would depend on the circumstances in the facts.
Okay, just quickly, there's a question. Often we defend that contractor that he has carried out extra work variation to scope that has been completed in good faith. So what Purushottam is saying, often we defend that the contractor has carried out extra work variation to scope that has been completed in good faith and intent and spirit of agreement. But then there's a risk of getting rejected as it is not notified and accepted. It is not out for the agreement and therefore a risk of getting registered. To what extent we can apply the good faith? So what Purushottam is saying is that contractors goes on and do additional work in good faith. When we get to final account, the project manager says, sorry, the client has run out of money. So to what extent we can apply the good faith in construction? Mark, maybe a few words on this.
So what is always good practice is that any additional work that's requested or required, get it in writing. That way you then make it a liquid agreement. Because when it's in writing, you can then say, but this is an instruction from you. I'm bound. Certain contract says that you are bound to follow instructions and then fight later. But then it becomes a liquid like a check, and you can act upon that. So I would always recommend that when any instruction is given, because even if it's verbal, just send an email and say, I would like to confirm this instruction and send it out. There's always a paper trail in terms of that, because most contracts says that communication should be in a form that can be reproduced or printed or stored. So it's always good to keep it in terms of that. Yes, you will never ever stop a situation whereby you do additional work and then other party then say, oh, sorry, I can't, or they refuse to pay for it. But then you've got mechanisms in your contract that allows you to recover it. But get it down in writing.
Yes, absolutely. There's a question from Sanesh Reshma. Can good faith be imposed if not expressed in the contract?
Well, we talked.
Mark is nodding. Mark is nodding. Mark is saying no.
No, sorry. No.
Well, as we said before, it would depend on what type of jurisdiction you're in. It would depend on the governing law of the contract. So is there a duty of good faith in the jurisdiction where you are? Or, for example, in common law jurisdiction, good faith cannot be implied unless there are specific circumstances. So it would depend on all of that. So in the Middle East, for example, there is generally a duty of good faith. So irrespective of whether the contract specifies it or not, you can advocate, you can bring in good faith.
All right, fantastic. Last question to Mark. What is the difference between good faith and utmost good faith? Are they the same, or is utmost good faith more intense?
No, there's no difference. Good faith, utmost good faith, the same thing. There can't be a degree of good faith. There is a case law under UK jurisdiction where the presiding judge said that good faith or utmost good faith doesn't matter. You don't have degrees of good faith. You either act in good faith or you don't act in good faith.
Wow. Okay, so look, we've got a few minutes left. I'm just going to launch a poll quickly, and the poll is just going to come over to you. Based on the presentation today and going forward, would you like to ensure and apply good faith in your project from a legal standpoint? So, of course, we had a split of 65 versus 75. Be good to see, based on the presentation today and going forward, would you like to ensure and apply good faith in your project from a legal standpoint? So I'm just going to stop here and share the result. What's your thought on that, Mark? What's the stat, do you think?
I'll plead the fifth.
Okay, and what about Reshma?
I think it's an overwhelming yes.
Okay, so we've got 97% says yes, we would like to ensure and apply good faith. And already you can see a turnaround of 30%. There was only one person who said no, and maybe it's dinner time in Mauritius, and understand maybe the person is hungry. So fantastic. And of course, thank you very much indeed for a 97% response. Thank you very much indeed. We are 100 of you turning out today. And just quickly, Reshma, we will have the honor, privilege to have you in Mauritius on the 9th of September for a workshop in the International Arbitration Center in Port Louis in Koda. And the workshop will be protecting your construction project. Maybe a few words on this, Reshma, before we conclude.
Sure. So I will be delivering this workshop along with Andrea. Andrea is a case counsel at the MIAC, the Mauritius International Arbitration Center, and we are working on this workshop, and we'll be delivering this workshop specifically for people who have who are involved in the construction industry, to try and guide people in dealing with their disputes better. So we will be covering things like dispute prevention, dispute avoidance, what to do before you start a project, what to do during the construction stage, what sort of mechanisms can you incorporate in your contract so that you have the best or most efficient means to resolve your disputes. And we'll be addressing a few cases as well. So I invite you all to come and participate.
Fantastic. So yeah, I'll be looking forward. I'll be sending the invite. Can't wait for the workshop to happen on the 9th of September in exactly 4 weeks. Yeah, we'll be sending the invite. Mark, just before I conclude, the word of wisdom from both of you. Please, if you can send me your full name and your feedback, especially on the webinar, that'd be great, so that I can share with everyone. I can't thank you enough for being part of this amazing webinar again. Mark, this is my 97th webinar. It's gone so quick, 1 hour and 30 minutes. We can talk all night, really, on good faith. Your final word of wisdom when it comes to good faith, and what advice would you be giving to us colleagues watching Mauritius? We've got various colleagues watching us from different country part of the world, really, in 4 continents today. What's your word of wisdom to all of us to really promote and enhance, good standard and make our industry much more of a collaborative? And I think you talk about mutual trust, cooperation, respect, collaboration. All these words are close to my heart. Few words on that, Mark.
From my perspective, what I would say is that it doesn't matter how the opposing person treats you, as long as you stay true to acting in good faith, entering your contract with honesty, with a clear conscience, and regardless of what the outcome is, always stick to your principles and ensure that you always comply or subscribe to good faith. Because if you act in a certain manner, you can by your actions change someone else's view. May not always happen, but that's always the intention. For the construction industry to survive and to thrive, and to become once again a top sector, everybody needs to play his part into acting in good faith and working together in good faith. And whether you're a member of the RICS, CILB, CIRB, all about ethics, how we deal with people, how we treat people, how we interact with each other in a commercial setting. And that is, and we can do that, I think we'll go a long way to resolving disputes.
And Mark, just a quick one, the whole webinar today stemmed up from your study, right? And there's a nice question at the end from an anonymous attendee. When listening to Reshma, it seemed there has been a start of understanding where both parties try to make an effort to have better work environment. But what is the percentage of good faith? Do we have that? So, I mean, is there some sort of percentage we can work on? I'll come into Reshma, but Mark, just to conclude.
I think you should give 100% good faith. Because if you're not going to give 100% good faith, that means that you are coming into a environment with an angle. You got an end goal. Your only end goal should be that I want to finish this project on time, within budget, and be successful in this project. Not with I want to try and make an additional $30 million or euros, whatever, or how I can take this person to arbitration. That doesn't work. It doesn't help. It becomes a lot costlier. Acting in good faith is very cost effective. You can resolve the issues on the table with the right partnership, and it all stems down when you enter into a contract. Parties need to be aware of the obligations, and one of the obligations should be discussed is how do we act in good faith? What are the pitfalls to achieving good faith? And that is how I see it.
Thank you, Mark. Reshma, final word of wisdom. Our fifth webinar, similar to Mark. Your final word of wisdom, good faith. Can't wait to see you in 4 weeks' time for our workshop. Maybe a few words on your final word of wisdom when it comes to good faith.
Thank you. Thank you very much, Anil. Well, I think that when parties enter into a contract, what they want is the success of the project, right? And at that point in time, there are common interests, but as we know on construction projects, disputes are quite inherent in the sense that there are conflicting interests, right? The employer wants to have a project completed with the least resources within the less period of time, whereas the contractor may want to invest the least resources and maybe protract time or maximize its profits, basically. So I think at the beginning it's easy to act in good faith, but then when things get complicated, then parties tend to review that behavior. But across the board, generally what we see is that the more parties invest their time and approach in having a disputes, a solutions-focused mindset, which is also aligned with a good faith approach, the more likely it will be that they will find a solution which is a win-win situation for both parties. And that's my message, really. Try to continue, don't just express good faith at the beginning of the contract or before entering into the contract, but try to maintain that behavior throughout.
Fantastic. Thank you, Reshma. We've just passed 1 hour and 30 minutes of CPD hours. We were supposed to finish that in 1 hour, but I think quite rightly we've got 1 hour and 30 minutes of CPD. Mark and Reshma, I just wanted from the bottom of my heart and from all the participants today, thank you so much. Guys, if you can put your emoji ups on your Zoom, just so thank you to Mark Watson and Reshma Oogoroah, both who've been willing to give 5 webinars at the start of the COVID, in the middle of the COVID, at the end of the COVID, and post-COVID-19. So I can't thank you enough. And for the first time in the history of webinar, we've got Winnie the Pooh at the back of Reshma's screen there. And to me, that's groundbreaking stuff. Mark and Reshma, thank you. We'll catch up next time. And thank you much indeed. And we'll see you when we see you. Guys, thank you much indeed. But please email me your feedback as well. So away from you, Reshma and Mark, thank you very much indeed and take care. Thank you, guys. Thank you very much indeed. And we'll see you next. All right, take care. Bye.